All right, council, good afternoon. My name is Steve Hill. I've been designated by our chief judge as the presiding judge of this panel. We're hearing the docket of March 7th, 2022 in the Kansas Court of Appeals. I'm pleased to tell you that on the panel is Judge Anthony Powell and Judge Amy Klein. And we're ready to go. We've read your briefs. We've received a research memorandum concerning your case. And I can tell you that 15 minutes isn't very long. So I suggest that you hit us with your best shot right up front. Be prepared for some questions. We might have one or two for you as you proceed with your argument. If you represent the appellant, when we ask for your appearance and you want to reserve some time for rebuttal, let me know that as well. All right, we'll hear, let's see, we'll have the appearance of counsel for the appellant.
Bruce Brumley appears for the appellant via Zoom conference.
And do you wish time for rebuttal?
Yes, 3 minutes, Your Honor.
3 minutes, you have it. And for the appellee?
Yes, Your Honor. May it please the court, Kip Cuban appears for the respondent, appellee, City of Lawrence, Kansas.
This is a workers' compensation appeal, if I remember correctly. And Mr. Brumley, let's hear from you, the appellant.
All right. Thank you, Your Honor. This is a workers' compensation case. It involves KSA 44 523 subparagraph F. There's really, from the claimant's perspective, and I agree, there's not a lot of time. It's three fairly, or at least two fairly big issues to look at. From the claimant's perspective, there's three big issues that relate to that statute. What happened in this case, if you recall, is that the case was dismissed with a pro se claimant under 44-523 subsection F, paragraph 2. What that paragraph relates to is a 1 year time limit after a case is denied for the claimant, the injured worker, to get to a regular hearing or re-challenge that finding in another preliminary hearing. The claimant didn't do so, and Judge Roth, the administrative law judge, ultimately dismissed the case for lack of prosecution under that statute. It went to the board, and we are now here. We have three basic reasons that we believe that the courts or agencies are in error. And I'm going to go in kind of a little bit of different order that was in the brief. The first, we believe that good faith existed as defined under KSA 44-523 F2 for an extension to be granted. Number two, and I believe the agency or courts below, which is actually an issue as to how you phrase it in this case, focused on this issue more than the good faith issue. They didn't really, in my opinion, and I would argue to this court, address that issue adequately, is whether or not the COVID regulations put out by the Supreme Court and the Justice of the Supreme Court put out regulations which told certain timelines. In particular, we're looking at Administrative Rule 2020 PR 16, which told timelines for judicial proceedings in any statute. I had it written down. In any time statute, I believe is the wordage of the regulation. We believe that regulation applies to the administrative courts in the Division of Workers' Compensation. The last argument, which was really raised in the dissent by the board, and I'm not going to focus a lot on this one, I'm going to leave that to the brief, is that respondent filed their motion 1 day premature. So there is the position that there is no such motion for a dismissal under KSA 44, 523, subsection F, paragraph 2. I'm going to focus primarily on the first two arguments. I want to turn to what I think is an issue which was kind of ignored by the board and the ALJ, which is whether or not good faith existed to allow an extension. In other words, if we didn't have this COVID issue and we're simply applying the motion, was there good faith? Neither the board nor the board found good faith. They essentially took the position, I would assert, that he was pro se and he should have known what he was doing. I understand that a pro se claimant, in terms of decision making on substantive issues, is not supposed to gain any preference just because he was pro se. But this statute doesn't relate to that issue. It relates to whether or not good faith exists to offer an extension. Your Honor, how much time do I have left?
Yeah, let me see. You got 7.5 minutes.
On my 12.
Yeah, without getting into your rebuttal.
Thank you, sir. But we're not dealing with a decision substantive issue. We're dealing with whether or not good faith existed for this claimant to have an extension to move forward with his case. And I believe good faith did exist. He was looking for an attorney. Something that nobody really talked about in the decision below, I believe if he had an attorney, he would have won his preliminary hearing. He went to a preliminary hearing on his own and basically didn't understand the prevailing factor standard, which is a standard where there must be this magic language where an injury is covered under the prevailing factor. To me, it's kind of like property law. It's like if you look at all the sticks, which of the stick is the biggest in terms of causing the injury. He provided evidence that stated in the doctor's report, so certainly the cause of the injury seems to be the accident. Well, the doctor didn't say prevailing factor. An attorney competent in work comp would have contacted the doctor and simply had that language added, and he most likely would have won his case. I point that out in terms of good faith, in that although a pro se client didn't understand that, if he had hired an attorney and the extension had been granted, this is not one of those cases where he would have lost anyways. This is a case where he likely would have prevailed if an attorney had gotten the treating doctor that he used for his condition to say the prevailing factor language. In other words, he would win. Also, in terms of good faith, I'm going to reference the COVID-19, not so much in tolling the statute on the timeline, the 1 year, but in terms of he was looking for an attorney. He testified that in his May hearing.
Counsel,
Yes,
can I ask you a question about that particular issue?
of course.
Anything in the record that reflects when your client began to look for an attorney? Because I can't tell whether it was before or after the motion to dismiss was filed.
Without
Am I missing something?
the only time that I believe it's referenced was in his pro se May hearing. And I had not read that. I've looked at a lot of things this morning, but I believe it was at least implied that he was looking before the deadline. That would be my position. I don't have anything else other than that here to reference.
Just the one comment made at that preliminary, or at that hearing on the motion to dismiss?
Yes, I mean, I can offer what he told me, but I know that's not what you want.
Right. No, I'm, and you're correct. I'm just trying to figure out if there's something else in the record that I'm missing.
Okay. And I can't remember what I put in my brief, if I put what he told me in that brief, which would be part of the record, but
I don't see anything in the record that reflects how COVID-19 actually affected your client's ability to proceed. I mean, I guess we can all agree that it was, I think, impacted maybe the last 22 days of the deadline. Is that correct? That's when
I agree.
the administrative order came about.
When the administrative order came about, but I believe things were closing down before that.
And is there anything in the record that reflects exactly how this pandemic impacted your client's ability to move his case forward?
I believe I argued in my brief that he was having trouble finding an attorney. My particular office never closed during COVID. We're a two-man shop, or a man and woman shop. And we were able to social distance pretty easily. I don't know. It would be my position that COVID-19 made it harder for him to find an attorney to help.
We don't have an affidavit from your client in which he describes his efforts or any specifics in that regard. Is that correct?
This is where hindsight would kick in. No, there's no affidavit.
That's fair. Thank you.
No problem. Your Honor, how much time do I have left on my 12 minutes?
2 minutes and 26 seconds.
Okay, thank you. I may run a little over on my initial statements then.
Well, that's all right. I'll just take it off your 3
I
minutes.
understand. One of the advantages of doing this by this, I have a little clock right on my computer screen that I can watch too. One other thing that I argued to the courts below, he was pro se. He knew about the 3-year limit in subsection 1, but he didn't know about the prohibition in subsection 2. I think I'm just going to say it and you can take it for what it's worth. The decisions by our judges in the work comp offices do not provide any notices as to their timelines on appeal. Other courts do. So security tell their pro se claimants that you have 60 days to appeal. Our unemployment in Kansas tell them that they have 16 days to appeal. I think as part of good faith, that notice should have been given to a pro se claimant. The only notice the judge gave, I believe, was that he should hire an attorney, which is wise advice. Judge Ross is a good judge. I'm not going to trash Judge Ross. He's a great judge. Okay, with the time I have left, I want to talk about the other argument, which is really interesting, is whether or not the Chief Justice's regulation applies to an administrative agency. Our main points on that are pretty heavily described in our brief, but we would define the work comp agency as a judicial proceeding or a quasi-judicial proceeding. When you read Administrative Order 16, 2016, it doesn't talk about district courts, it talks about judicial proceedings. Now, I want to talk about something that wasn't in the brief. Sometimes you see this thing a little bit clearer afterwards. The Chief Justice authority to issue that order is in KSA 20-172. That statute allows the Chief Justice to extend or suspend timelines when there's an emergency.
You're into your rebuttal time now, Counsel.
Oh, thank you, sir. Could you tell me when I have 1 minute left?
I will.
Thank you. I believe that statute gives the Chief Justice authority to do what she did. Then, unfortunately, I think you have to look. I say unfortunately because it involves constitutional issues. I think you have to look at Article 3. This was not referenced in our brief. It was something I thought about this morning when I was preparing for this. Article 3 states that the judicial power of the state should be vested in one court of justice which will be divided into one Supreme Court, district courts, and such other courts as provided by law. It would be our position to this Honorable Court of Appeals that the phrase "and such other courts" would include administrative tribunals such as the Division of Work Comp. And by doing so, gives the Chief Justice jurisdiction to apply the regulations to administrative tribunals, which brings me to my final argument. I wish I had 30 minutes. I could use the whole thing. It doesn't make sense from a constitutional standpoint. This was addressed in our brief in some detail, to treat an injured person from a car accident in a district court by one standard and an injured person in a factory that was hit by a forklift, which wasn't this accident, I'm pulling that out of the air, differently. They're both, the Division of Work Comp is clearly a tribunal. They don't perform an executive function. Which is why we don't believe separation of powers applies. They perform purely a quasi-judicial function, with the case in controversy being their disability, payment of medical bills. I believe the 1 year part comes out. I know there was a regulation put out by the Division of Work Comp that addressed it, where they went to the phone hearings, but you have to understand, one of the things we're trying to do is get denied medical benefits paid for by these injured workers. So they couldn't completely shut down. But I still think the concerns related to being able to file motions and protect themselves.
You've got about a minute, counsel.
Thank you. Would still warrant the tolling to apply to the quasi-judicial proceeding administrative agency. I would reserve the rest of my time.
All right, counsel.
Thank you.
I'll make sure that you get a couple of minutes for rebuttal.
Awesome. Thank you.
All right, counsel, we'll hear from the appellee.
May it please the court, your honors. Thank you for the opportunity to argue this case today. Aside from feeling like the the ethics presenter at a seminar where you're the last person up, I will try and make my comments brief. I do not think I will take my entire 15 minutes.
We punish no advocate for failing to use all of their time. Rest assured about that, counsel.
The arguments that Mr. Brumley has raised in his argument today, I think are also addressed by us in our brief, but I do want to highlight a few things that he focused on today during the argument. The first argument he wanted to focus on was whether or not there was good faith. And that leads us inexorably to the other disagreement we have between the parties, and that is, what is the proper standard of review for that particular issue? In this case, the respondent submits that this was a negative finding by the court, and that because it was a negative finding by the court, a different standard is applied than basically the unlimited standard, or at least the wider standard that's utilized by the court in either legal issues or mixed issues of fact and law. In this case, since the court held that there was a failure of proof on behalf of the claimant to show good faith, that this court should treat that as a negative finding, which would mean that arbitrary disregard would be the proper standard for this particular factual issue in front of the court. That being aside, it also is worthwhile for me to submit that the court is limited by the record, and the record would be basically the transcript of the preliminary hearing, which was conducted by the court, I believe in April of, I don't have the date in front of me, but it was earlier of the two hearings, and then the dismissal hearing in May of 2020. In the dismissal hearing, the court gave the claimant every opportunity to articulate what he thought a good faith reason was for his case not getting dismissed. And the claimant, the most he could say is that he was attempting to get counsel. He never tells us what attempts he made to get counsel. He never tells us the contacts that he's tried to make. He never tells us whether or not he tried to get counsel prior to the motion to dismiss being filed. I think something that should be noted for the court is that the claimant did have prior counsel in the matter. He was not always pro se in the claim. Initially, his claim was filed by an attorney, and for whatever reason, his attorney withdrew, and he had 18 months to obtain counsel prior to the hearing on the motion to dismiss, and at no time obtained counsel prior to that. So when Mr. Brumley urges that as a basis for good faith moving the case along, I'm not sure that it meets that standard. The Court of Appeals, a different panel, set forth the Green case a couple of weeks ago on February 25th, where they discuss the element of good faith. And what they say in that case is that the lack of prosecution entails a party's failure to pursue an action with due diligence would be the operative part of that holding. And there's nothing.
That's a lot more precise, isn't it?
Well, this is not necessarily a science-based particular point. It's more of an art. However, it does give us some guidance that there has to be some showing, or the court would like to see some showing that there's been some diligence in pursuit of the case. And that's what we're missing in this case. There is no evidence of the element of diligence, if you will. The claimant did not pursue the case for a year after his preliminary hearing finding was determined to be not a compensable accident. And at that point in time, took no efforts, even after the motion to dismiss was filed, to obtain counsel. He only obtained counsel 6 weeks after the motion to dismiss was held and was filed, and the hearing held before he even obtained counsel in the matter. So I'm not sure that that meets the rather open, broad standard of diligence as outlined by this court. The second argument that Mr. Brumley makes about good faith is the fact that the claimant was pro se, and that in itself is an element that should indicate good faith. That would be contrary to the prior holdings of this court and also the Kansas Supreme Court, that a pro se litigant is treated with the same standards as an attorney. In this case, even after the preliminary hearing, the court urged the claimant to get counsel. He simply just didn't do it, or rather to replace his counsel, which he just simply didn't do. I think it's speculation on Mr. Brumley's part that the claimant would have won his preliminary hearing had he had counsel, because the court considered the evidence that Mr. Brumley pointed to in his brief about his doctor saying that the claimant's, the cause of his current condition was his accident while working for the city of Lawrence. The court weighed that evidence along with the rest of the evidence at the preliminary hearing, mostly the evidence from the doctor who had seen him before the Lawrence accident and also saw him after the Lawrence accident, who arguably would have been in a better position to tell what was related to that accident and what was not related to that accident. Finally, Mr. Brumley's last point on that was that the claimant said he did not know about the 1 year statutory timeline to proceed to final hearing or to resolve his case before it was in danger of being dismissed. I think that that would be counterintuitive, if you will, to his statement on the record that he knew that there was a 3-year prohibition connected with the statute, and also counterintuitive to the judge's admonition at the preliminary hearing that there are time periods that affected his case, and that if he didn't acquaint himself with those time periods, there was a risk that his case would be dismissed. Unless there are any other questions on the good faith aspect of it, I'll move on to the second point that he was making, and that was that the court had the authority to, if you will, usurp the administrative division's ability to control their functions under the Department of Labor. We address this in great detail in our brief and talk about the test that's been set forth by the Kansas Court of Appeals and the Kansas Supreme Court as to whether or not there's been a violation of the separation of powers. Briefly stating, the separation of powers on the federal level is mimicked by Kansas and approximately the same type of issue under Kansas law as it would be under the federal law. The point I would make in regard to the separation of powers is that the division never did shut down, as noted in the brief. The division set out its own operative plan approximately a week after the court's plan was published, and that Mr. Brumley's argument to that extent doesn't make any sense that that the court would approve or endorse a conflicting standard to one that had been put out by the administrative agency. I don't think that the court has that kind of power, nor sought that kind of power in doing it. Suffice it this, go ahead.
You talk a lot about separation of powers in your brief and today, but do we have to reach the issue of whether the Chief Justice had the authority to stay deadlines in the workers' compensation proceedings, or can we simply just look at the language of the order and decide what was her intent? Do we have to reach the authority issue in this case?
I argue it both ways in the brief. I also argue that if you look at the language of the order that was issued by Justice Lukert, it's not broad enough to encompass the administrative law court. So in answer to your question, no, you do not have to reach the authority issue. You can simply look at the language of the order and say that it's not broad enough to encompass that, at least in my view. The last point that Mr. Brumley focuses on in his argument is that it's unfair for a person to be treated differently in civil court than it is in a workers' compensation claim. And if I might submit to the court, that's really the issue that has been soaking up a lot of the oxygen with the Johnson case and going clear back to the Franklin case and even as far back as Hughes versus Inland Container. And in all those cases where the court has considered whether or not the Workers' Compensation Act is constitutional because it provides different benefits than a person would be entitled to if they had a civil case regarding those same issues, they've always affirmed that there was a reasonable basis for the Workers' Compensation Act to exist and that there was a sufficient quid pro quo for that to take place. So I think that really Mr. Brumley's point there is just a restatement of that argument. And I believe that to be settled law in regard to whether or not you can have an alternative remedy for an injury case. And the example of that would be the workers' compensation claim. Another area where that issues come up is in the no-fault insurance claim, where if you do not have sufficient damages, you cannot proceed to a civil case. And again, that's been found to be a sufficient quid pro quo. So I don't think that the argument that Mr. Brumley makes is well-founded. The last point I would make is really just a matter of interpretation of a case, and it's more from an historical point because, forgive me, but I think that maybe Judge Hill might be the only other person besides me who was old enough to realize that district courts used to handle appeals of workers' compensation claims.
Indeed, I have handled several of them in my time on the bench.
And I think I might have even handled some in front of you back in those days, Your Honor.
You might have.
But the point that I was going to make is when the claimant relies on cases like Galwith and Reeves, those cases are probably undoubtedly referring to an arcane procedure that no longer exists. Since 1993, the appeals for workers' compensation claims have not gone to the district courts, but have been a purely administrative proceeding. And since 1993, have been controlled exclusively by the KJRA. So I guess what I'm saying is that as a cautionary note, when you're reading some of these cases that are being cited, you have to keep in mind that that was a different concept and different approach to the law at that point in time. So with that historical admonition in place, unless the court has any additional questions, I have no other comments.
Any questions from the panel? All right, thank you, counsel.
Thank you.
All right, counsel, how about 3 minutes for your rebuttal?
That's very gracious. Thank you, Your Honor.
Okay.
First, I do remember the de novo appeals to the district court. I came out in 93, so there were still some of those around when I came out. And I've practiced work comp a lot since then. I have expanded into other areas. But with that note, I'd like to refer to the Garrell versus Gage case. That case is, I believe, from 1970, so I understand counsel's comments on that. But really, the relevant portions of that case don't talk about the procedure so much of going to the district court, or as it is now, straight to the Court of Appeals. What I believe is relevant in those cases is that it defines the difference between an agency that is a more of an executory function, like the KBI that enforces law, or a quasi-judicial function, such as what work comp does. Work comp settles case and controversies in every hearing it holds practically. There are some procedural issues such as statutory interpretation that might come up, but they're not on any fact-finding mission. They decide facts, they decide law very much as our district courts do. So kind of getting to what Judge Klein was possibly getting to, the work comp courts are a judicial finding, a judicial proceeding. They make determinations, they issue awards, they issue orders. Quite frankly, they move a lot of money with the disability, with the wide range of work comp cases that come before them. Also, if we're just going to interpret the intent of Administrative Rule 16, 2020 PR 16, I think we win. I mean, that does the language of that regulation says judicial proceeding. Or statute affecting timelines. This is a statute affecting timelines. The work comp courts are a judicial proceeding. It falls within that language. Also, as to the issue of good faith, I disagree adamantly that this is a fact question with a negative finding. This is a mixed fact and law question as to what the phrase good faith means in that statute. If this was under the substantial evidence standard, the appeals board doesn't really talk about the good faith thing. They kind of focused on how I was wrong on the COVID tolling thing, more so as I read the decision.
Counsel, you're getting to the last few seconds if you want to sum up.
Well, in summary, as to good faith, I think when you interpret good faith with a pro se claimant, I think he is entitled to some deference. He knew the 3 year, but he didn't know the 1 year, and the judge never told him about the 1 year. Thank you, Your Honor.
Thank
I
you.
wish I had more time.
Yeah, you're not the first counsel to say that.
I bet I'm one of many.
Listen, it's been very interesting arguments today. I thank you both for that. We will take this case under advisement and issue a decision as soon as we can. Thank you very much for your arguments. We will now adjourn.
Thank you, judges.
Thank you to the